death of a tenant. And again, we've actually had 3 questions about this to various trainers this week from all over different parts of the state. So it seems to be a topic that people want to talk about, or at least what to do. So the calls are coming in from property managers, and it's about what to do when there is the death of a tenant. So, fair call for a question. Now, if you have a sole tenant, so there's not multiple people living in the property, it is a sole tenant, and on the death of that sole tenant, under a residential tenancy agreement, either the landlord or the tenant's legal representative can give a termination notice to the other person. So it goes either way on this one. There is no minimum notice period. So it's all about vacant possession, this termination notice. Now, there's nothing in the legislation that talks about the minimum notice period. However, if you go to the fair trading site, you start looking at the termination, the standard termination notices and the information that fair trading have on their website, there is no minimum notice period. So that's where you'll find that type of information. Now, the termination notice that is issued may specify a termination date that is before the end of a fixed term. So even if they're in a fixed term, you can't hold that fixed term lease against that deceased tenant. Okay, so they're not there. It's a termination notice, even if it's in a fixed term agreement. Makes sense. But however, it obviously needs to be in legislation to deal with that issue. Okay, if it's taken to tribunal, so if there's an application to NCAT either by the landlord, so that's probably you as an agent doing that application, or if the application comes from the deceased tenant's legal representative, the tribunal may make a termination order if it's satisfied that the termination notice was given in accordance with this section of the Act, which is Section 108 of the Residential Tenancies Act, and that vacant possession of the residential premises has not been given as required by the notice. So if you as an agent, talk this through from a reality point of view, you as an agent have issued a termination notice. It's put when you expect to receive vacant possession in terms of when all of the deceased tenant's belongings will be removed from the premises, and that hasn't occurred, then that's when you would make that application to tribunal and looking for an order to be made that you need to be given vacant possession. Okay. So if a deceased tenant's legal representative is given a termination notice by the landlord, or obviously from you as the agent representing the landlord, they obviously can give vacant possession of the premises at any time before the termination date specified in the termination notice. So if you give them two weeks to get everything out, or however long, and they have it all out by tomorrow, then that's fine. That's the last day they pay. So it's the end of that's. They can certainly move out, and that's the end of the payment period. So it's on a per day basis until you get vacant possession, obviously, in terms of paying for that, the remainder of their time in the premises. Okay. The estate of the deceased tenant is not liable to pay any rent for any period after the legal representative gives vacant possession of the residential premises. So there's no, you can hold them till the end of the lease term, or you can get a break lease fee for whatever that break lease fee is in effect in terms of where it fits into the fixed term agreement. So it really is quite straightforward. Termination notice needs to be issued. It needs to have it's all about vacant possession. There's no minimum notice. So, it could be, depending on what the situation is. Now, of course, if you don't know who the legal representative is, if there is no next of kin to contact and discuss these issues with and actually issue notices to, then clearly you take it straight to tribunal. There's a whole range of different ways that this can go, but it's a tribunal issue to actually make orders and work out what to do with this. So it's straight off to tribunal if there's no next of kin, which comes back to your application forms. Really, in reality, comes straight back to your application forms of when a new tenant makes an application for a property. You ask for next of kin for a reason. You ask for another contact for a reason. There are a whole lot of negative reasons about, behaviour of the tenant and abandonment of property and all those sorts of things. But this is just another one where you really do need an alternative contact for this person when something goes wrong. So guys, it's Section 108 of the Residential Tenancies Act. If you want to read about it, it's a little bit I guess, verbose in terms of how it's put together, but there's also some good information on the Fair Trading website about what you as a landlord, therefore you as an agent, are doing on behalf of your landlord, need to do in this situation when it's a sole tenant.